We'll call the next case on the morning docket, 117162, State of Kansas versus Christopher Dale.
May it please the court, Peter Meharry for Christopher Dale. If I could reserve 3 minutes of my time for rebuttal, Your Honor.
3 minutes is reserved.
Thank you. In this case, Mr. Dale was originally convicted of 2 counts of aggravated robbery and 1 count of theft. That arose out of an incident back in 2009 in a skate park in Olathe, Kansas. At that time, an individual by the name of Drake Rickerson approached several other individuals in that park offering to sell an iPod. That devolved into kind of a confrontation between the individuals. Mr. Rickerson then left, called his cousin, Megan Clark, and my client, Christopher Dale, at the time was dating her. Rickerson told them both what occurred, and Dale and Megan Clark went to the park. Dale and Rickerson then approached the individuals, 2 of which were on a bench. Mr. Dale pulled what was a BB gun, put it to the head of one of the individuals, pointed it at the other, and in the process, there was some discrepancy, but Rickerson took several items that were sitting on the ground next to those individuals. From that, the state charged 2 counts of aggravated robbery for the 2 individuals on the bench, and a 3rd count of theft, because one of the items taken was a cell phone of a 3rd individual who was skating in the park a few little ways away. Mr. Dale appealed, and the Court of Appeals reversed on an instructional issue. It found that the instruction for the aggravated robbery convictions was clearly erroneous. It affirmed the theft conviction. It went back to the district court, where Dale argued that because he stood convicted of the theft conviction, the state could not retry him on the aggravated robbery convictions because the theft conviction was a lesser included offense of those aggravated robbery convictions. And under 21-3107, statutorily, you can be convicted of the greater or the lesser, but not both. And his argument was that if he would be convicted of those egg robbery convictions again, he would be convicted of both. District Court disagreed and found that the theft was not a lesser. Additionally, Dale argued the 2 egg robbery convictions were multiplicitous. Again, the District Court disagreed, and the case went to a bench trial. The District Court convicted my client of those 2 egg robbery convictions. The Court of Appeals found that the theft conviction was a lesser. It found that, in this case, theft was a lesser of the aggravated robberies. However, the remedy the Court of Appeals came up with was to reverse the theft conviction, as opposed to what we argued, reversing the aggravated robbery convictions. That is where we think the Court of Appeals erred. We are not challenging their finding that theft is a lesser in this case. What we are arguing is that because it is a lesser, as the Court of Appeals found, when it went back to the district court, my client stood convicted of the lesser. And as I said before, 21-3107 bars conviction of both the lesser and the greater. So that barred retrial on the greater offenses. And that was the procedural posture of the case in front of the Court of Appeals. It was the procedural posture of that case in front of the district court. And that is why the Court of Appeals erred, because it ignored that.
Isn't the case, wasn't the Court of Appeals correct about the case law regarding the general remedy when that situation arises in a prosecution, where they are prosecuted for lessers and greater offenses, that before sentence is imposed, the court can only sentence to the one, not to both?
The case law is that if you are convicted of the greater and the lesser, or multiplicitous offenses.
And so you have no disagreement with that case law?
That is what the case law has said, that you get rid of the lesser.
So we're just looking at, it's that application under these factual circumstances, in your view?
I don't believe that you can apply that to this situation because this is different in that he was standing convicted of the lesser.
How is this different when it's the same prosecution? That's where I'm having trouble. The case law indicates that statute is meant to codify double jeopardy, basically. And what I understand you to be relying on, double jeopardy, would be the second prosecution. But this is the same prosecution, isn't it? There's only one complaint that was at issue in both trials. So can you help me get past that?
This is the same case. What I would argue to the court is under 213107, it bars what the state did here because he stood convicted of the theft, the lesser included offense, and the state went ahead and tried him on the greater offenses and convicted him of those greater offenses.
How does the serial nature in the same prosecution any different than if this had than he was on his first appeal, when he was convicted of both on his first appeal?
Because I think when you look at what the situation was in district court, he stood convicted of the lesser. Whereas if you're looking at it the general, usual way this comes about, the jury is giving instructions on all of these offenses, and the jury is deciding at that point what to convict of. Here we have a conviction. We don't have a conviction of the lesser. We don't have a conviction of the greater offenses. That's still yet to be determined because it still has to go to trial before the district court on those greater offenses. And that is what is barred because he stood convicted of the lesser. So we don't think the Court of Appeals can ignore that because it wants to go with the general rule and reverse the lesser in situations that are factually and procedurally different than this case. So we would argue that the proper remedy the Court of Appeals should have done was to reverse the two aggravated robbery convictions. That is what we would ask this court to do, and the proper remedy is reversal of those two egg robberies, and the theft conviction, which has never been challenged in this appeal, would be then reinstated. The second issue deals with assuming or if this court does not agree with us on that, whether or not those two aggravated robbery convictions are multiplicitous. And we would argue that they are. This Court of Appeals looked heavily and relied heavily, I think, on the fact that there were two victims. There are two individuals sitting on the bench. But I think the focus should, rather than the victims, be on the fact that there was one forcible taking here. The Court of Appeals found that this was unitary conduct. The state agreed, at least in the district court, that this was unitary conduct. This was one act, and there was one taking. The evidence was that all of the items were on the ground, and they were just taken together. This is not a situation where you're taking items from one person, then moving along, taking items from a second person. And if this court looks at particularly the Pham court, which is 2006 case, that says a separate and distinct aggravated robbery occurs with the taking of property from each victim. And that's what we don't have here. He didn't take property from victim number one and then take property from victim number two. He pointed a gun at both of them and took the property together.
We have kind of a middle ground here between Pham and then that sort of classic point the gun, take something, point the gun, take something. Because here, he did have two individual threats made. One, he's got the gun next to the ear of one guy, and then the other guy, when he reacts to it, ends up with the gun in his chest, right?
That was the testimony.
Yeah. But that distinction is meaningless?
I think it's meaningless. I would point the court two reasons. Number one, the Court of Appeals already found this was unitary conduct. This was one act. And when you dive into it, as far as robbery, what the court should look at is the forcible taking. And here, the evidence was that the items were taken together. You don't have items taken from the first person, and then force and items taken from the second person. You have force and one taking. And that's why when you look at Pham, they talk about taking property from each victim.
But except that happened here. Property was taken from each victim. Just because I have property located in close proximity to me on the ground, I didn't necessarily give up that property except for the force and fear that was given to me as a result of the actions of your client. I mean,
The property certainly belonged to multiple victims. But when you look at aggravated robbery, you got to look at the forcible taking. And when was the forcible taking? He used force, and there was one taking because all of the property was taken together. And I think if you don't draw that distinction, in this case, the example is you go into a bank and you steal money. Presumably, you're taking that, there's probably a bunch of people in the lobby. Is that multiple aggravated robberies? And I would argue no. I think that's one aggravated robbery because you have one forcible taking. You point the gun at the teller and say, give me your money.
It seems though
No, it's
that
different.
the focus has often been on ownership and how many owners there may be. I mean, there are some cases where a store is robbed, two employees are part of, point here, point there. But the analysis has really been that the property belonged to one store. Here we have a difference with that because we have two owners, both of whom had some threat to give up their property.
Well, again, I
So
would
is
argue
it-
that there's really only one act. This is unitary conduct.
But
I
that's
understand.
our first prong. Our second prong is we look at the unit of prosecution as defined by the legislature.
Correct.
So what language do you, what do you really think is the evidence of the legislative intent to apply to this case?
When you look at the aggravated robbery, I think you'd look at what's the heart of the crime. And I think the heart of a crime for an aggravated robbery is the forcible taking. You've got to have that marriage between the force and the taking. And here, we only have one taking. There was force used, the gun was pointed at both individuals. But that, I think, is a continuum of force, one overarching use of force to go with that one taking when they took everything together.
So if you have a group of people that someone's holding up, pointing a gun at, throw your purses, your wallets, your rings on the floor, and they swoop them up, that's one robbery?
I think you can certainly make that argument, that is one robbery. It may be a fine line, but there is a line there between taking with force from person A, taking with force from person A, as opposed to taking once. And I think that's what aggravated robbery looks at, is the forcible taking. And that's, in this case, where we have one forcible taking.
Counsel, I have a related question, and it may not even be before us, but I'm baffled as to how the theft can be a lesser included offense of the robberies when the theft was of property belonging to a third individual.
Your Honor, number one, I don't think that is before this court. The Court of Appeals said that theft was a lesser. The state has not
So, right,
cross-petitioned.
and we don't have a cross petition, but as a matter of law, that finding is sort of a predicate of the issues that are before us, the double jeopardy and other issues. So I'm thinking that we might, well, anyway, I'm just curious as to how you would answer the question.
Number one, I don't think it's in front of this court, and I don't think it bars this court addressing the problems we see with the Court of Appeals opinion. And mainly that is that we believe that their manufactured remedy is incorrect as to whether or not the theft conviction should be reversed or the aggravated robberies. But secondarily, and this kind of ties it a little bit into the multiplicity argument, you have one taking here. And if you look at FAM, one of the things...
But that's slightly different. I realize there's a lot of overlap between multiplicity and whether something's a lesser included. But if we just focus on whether the theft is a lesser included offense, I don't see how it could be ever a lesser included offense. How could taking property from a third individual ever be a lesser included of a robbery of person A?
I think when you look at the facts here, you're dealing with, again, one taking. I don't want to say that too much, but we have one taking. So you look at, okay, there's this one aggravated robbery. Then, in that instance, I think you would say that theft would be a lesser included offense of that. Generally speaking, theft is a lesser of aggravated robbery. You have, theft is taking property, aggravated robbery.
It is when it's against the same victim and it deals with the same property.
And I think the emphasis in this case should not be on the victims. And I think that's part of where maybe this court or Court of Appeals is getting hung up. I think the focus needs to be on the taking. In this case, how many forcible takings were there?
But doesn't FAM say just the opposite? I mean, there is a sentence in FAM that says one transaction can support more than one count of aggravated robbery. You just said that under those facts, it didn't meet those circumstances.
The facts in FAM were that they went into a room, took items belonging to multiple people from the presence of one, and there was multiple egg robberies charged. And this court said, no, that's one taking, that's one aggravated robbery. So I think that supports the idea that if you have one taking, it can be an aggravated robbery, one aggravated robbery if it's one taking, even if the property taken belongs to multiple individuals.
But in that case, there was really only one application of force. They just stormed in, told everybody to hit the deck, took the stuff and got out. Isn't that right?
I thought it was they like tied a bunch of people in the living room, then went to a bedroom and used force there. But I think
those groups didn't pair with who owned what, did they?
No. My understanding is the property taken was taken in the presence of a third person, not the owners. But here we have one use of force. We have one forcible taking. As I said before, the Court of Appeals already found that this was unitary conduct. State, again, hasn't challenged that. They agreed to that in the district court, that this is one overarching act of force and one overarching act of taking of property. And that's why we believe it.
Is that equivalent? I mean, I'm not sure that's how we have defined unitary conduct as being a stipulation to elements of a crime. I'm not sure exactly what the stipulation, or what I'm not sure it was a stipulation, even I've gone too far there, but what the state agreed to in district court. Was it just as to the first prong, but did they really ever agree to the second prong? Which is what you're arguing.
They agreed that this was unitary conduct in district court. And that's in the record. I can get a cite for the court.
I understand that, but you went further and applied that to your definition of the unit of prosecution, and I'm trying to, I didn't go that far in the district court.
Well, I think as far as the unit of prosecution goes, my argument is that what you need to look at is the forcible taking. What is the taking involved here?
But the state didn't agree to necessarily your reading, did they?
As far as unit of prosecution, no.
Okay, that's all I was trying to
I don't
clarify.
know if there was really any discussion about unit of prosecution in the district court, but they did agree that this was unitary conduct. So from that, we believe that in this case, Court of Appeals erred, and this court should reverse the aggravated robbery convictions and reinstate the theft conviction. In the alternative, we would ask that this court find that the two egg robbery convictions are multiplicitous and reverse one of those convictions. Thank you.
Thank you. Mr. Gonteski?
Madam Chief Justice, and may it please the court, I'm Jacob Gonteski. I represent the plaintiff, the appellee, the state of Kansas, and in this case, I'm asking that you affirm the Court of Appeals ruling finding that they properly applied the principles of multiplicity when it vacated Dale's theft conviction.
So you think the theft is a lesser included of the robberies?
That is not, as counsel stated, that is not an issue that's here, but the part of the
But
rationale.
isn't it an underlying, as I said, predicate of what both sides are essentially asking us to do on opposite sides of the same coin? But the coin is the finding that this is a lesser included.
I agree with you, and I had not seen it that way until I was sitting here and I heard your question earlier.
Well, indulge me for a minute. Do you think the Court of Appeals, do you think that's legally correct? I mean, is that a good precedent to set going forward?
I struggle with that question because I can see in some contexts how it could be. if a bank robber goes in and holds up one teller and clears out all the safe deposit boxes, I'm not in a position to say that we could charge an aggravated robbery and a whole bunch of counts of theft for all the customers. I don't know that that would be the proper approach. I may be stepping out of my lane to say as much, but I don't know that that would be the proper approach for charging such a case. But which is essentially what we have here, which is the force being applied to 2 individuals on the bench, but the property was owned by 3 individuals when it was taken.
The property of the 3rd individual just was sitting nearby. Let's say it was sitting on the bench.
It was in the pile of goods that Mr. Dale took.
And the 2 weren't entrusted with its possession, from what I can understand.
As much as 16-year-olds do that with each other's goods at a skate park, I suppose so. Because one of them was off skating while the other 2 16-year-olds were on the bench and had the guns pointed at them.
But the evidence was they all just set their stuff down before they were skating.
Correct.
How could you possibly prove theft of that third party's item simply under the elements of robbery? I mean, doesn't the state have to prove that it was owned by another?
And we did. We
Sure,
proved,
but I'm getting at the lesser include. It seems to me that there are different elements at work between the robberies and the thefts, simply because of the different status of the property, the different ownership status of the property.
and that is how we originally charged it, and I can see how that was done that way, and how the district court, frankly, had affirmed as much when that was first raised upon remand. And the rationale was that it was not a lesser included because it was a different victim. We did not challenge that on the second appeal for various reasons, but we didn't, and so that's why it wasn't an issue that was explicitly briefed, even though I can respect the court's view that it's wrapped up into the same question about whether or not what the remedy should be if the court's going to be vacating one of the 2 convictions under the multiplicity analysis. The Court of Appeals, assuming the point being that theft is a lesser included and that the 2 are multiplicitous, the Court of Appeals correctly vacated the theft in providing Mr. Dale with the remedy that he was entitled to if those 2 convictions were going to be found multiplicitous. Mr. Dale would not be entitled to vacating the greater offense, the aggravated robberies, if he had timely pursued that claim of multiplicity as he should have done in his first appeal. It's essentially accepted by everyone that if he had pursued that in his first appeal or at the district court his first time through, and it had been found to be multiplicitous, then the remedy would have been to vacate the theft and sentence him upon the aggravated robbery. So the Court of Appeals properly applied those principles that have been longstanding under our case law. Furthermore, the court correctly found that the 2 aggravated robbery convictions were not multiplicitous. The reason why is this. Theft, understandably, the gravamen of theft is the taking of property. Somebody else's property without authority that's being taken as your own, permanently depriving another person of that property. The aggravated robbery statute is a very different creature of our statute books, because the aggravated robbery statute centers upon violence inflicted upon an individual, another person. The gravamen of aggravated robbery is applying that force to a person to achieve the ends of taking. This court should find that the gravamen of aggravated robbery, thus the proper unit of prosecution, is the force being applied to an individual. If that is the proper unit of prosecution, then here there would clearly be 2 aggravated robberies because Mr. Dale pointed his gun separately at 2 individuals to achieve his end of stealing the property that was held between the 2 of them, regardless of the victim.
How does that fit with FAM, though? Because the property was in the bedroom drawer.
Right.
And it happened to belong to a bunch of people, but
Yes.
they were clearly assaulting all the people in the house.
Understood. And I believe Justice Beyer had it correct earlier when she stated what we essentially have is sort of a middle ground between FAM, which held that only 1 count of aggravated robbery could be charged, In an earlier case, Jackson, which found multiple charges could be supported, multiple counts of aggravated robbery. In Pham, as I remember it, several family members were assaulted or otherwise occupied on one floor of a house. And then the Pham went upstairs to steal the property of a whole bunch of people, but applied force to one when he was in that bedroom so he could steal the dresser drawer full of jewelry or whatever it was. So in that case, arguably, there was one application of force, or the property was forcibly removed from the presence of just that one. And so the Pham court held that only one count of aggravated robbery could be supported by that series of facts.
Your argument would be that if in Pham the robber had taken 2 people into the bedroom, you could have charged 2 counts.
Absolutely. In Jackson, that's essentially what happened. In Jackson, the earlier case from 1975 involved a pattern whereby the robbers did impart force upon more than one person. I believe it was 3 in that case that had force applied to them to achieve Jackson's end. What makes this sort of a middle ground is that in Jackson, I believe the scenario did involve force applied to 1 and property taken from that victim. Force applied to 2 and then property taken from victim 2. Force applied to 3 and property taken from 3. Here we have the middle ground whereby force is applied separately and individually to 2 people to achieve the goal of taking the property held by both. And so, as I stated earlier, this court should recognize and appreciate the distinction between property crimes and that portion of our statute books that criminalizes theft and the like, whereby the gravamen of those non-person offenses is the taking of property. Those are property offenses. Aggravated robbery is not a property offense. This isn't a burglary. This isn't a theft. It's an aggravated robbery. The reason why it's elevated on our severity scale, the reason why it's placed in the person felony column, that's because this crime involves violence that's imparted upon a person, upon a victim. And here,
Let me take your, I'm going to go back to your earlier example about the bank robbery and the safe deposit box, because we were kicking that around in my office last night. Assume with me that in the lobby where the bank robbers are people who own stuff in the safe deposit box. So you've got, if I'm understanding you right, you've got a show of force with more than one person.
true.
You're going into the vault, and I suppose, and then the bank teller is letting them into or they're getting into the safe deposit box that belong to the people that you just showed force to. Does that let you rack up the count of aggravated robberies in that scenario?
I think it would be incredibly factually dependent upon how the use of force was applied to the customers in the lobby, frankly. If that helped those robbers
Help them get
achieve
into
the end.
safe deposit box, is that your distinction?
I'm sorry?
Did the exertion of force help them get into the safe deposit box?
Precisely. Here, the use of force that was applied to the 2 16-year-olds on the bench, Mr. Dale clearly apparently felt force needed to be applied to both of them for him to achieve his end of sweeping up the property, the electronics that was held by both, because they both resisted and he individually pressed his gun to both of them.
Are you still conceding that's one unitary act?
In the district court below, the state did concede that it was unitary conduct, which would be the first prong of the multiplicity analysis. I recognize, and there was a reply brief that was filed here, and I recognize as much by opposing counsel that the state did concede unitary conduct, that first prong of multiplicity here at the court below, and I'm stuck with that. I recognize as much. But I don't believe as though unitary conduct necessarily answers the second question, which is the unit of prosecution test. I believe the reason why there are those 2 factors, those 2 considerations, is that unitary conduct does not always answer the question of what is the proper unit of prosecution. There can be unitary conduct, which the state had conceded here, which was one big event that occurred at the skate park that day. It was part of, as the Court of Appeals said, it was part of one plan to steal a host of property. So arguably that makes it unitary conduct. However, Moving on to the second step, which of the multiplicity analysis, if you're looking at this two offenses charged under the same statute, which is what we have here, then the question becomes what the proper unit of prosecution is. And my argument is the proper unit of prosecution is examining the aggravated robbery statute itself closely, recognizing the fact that the gravamen of aggravated robbery is the person offense, the violence imparted upon one individual. That's the state's position on the aggravated robbery count and why 2 aggravated robbery counts are both supported here. With the time I have remaining, I would like to highlight a portion of why my earlier claim about the Court of Appeals remedy was proper. In this case, Mr. Dale did not raise his multiplicity argument in his first appeal. He raised some instructional issues, some other issues that were not decided in his favor, but the Court of Appeals reversed his convictions, just the aggravated robbery convictions, due to instructional error. Affirmed the theft, and it was sent back for a new trial on the aggravated robbery charges. That's when the multiplicity claims first arose. If this court is to allow Mr. Dale to wriggle out of the aggravated robbery convictions because the Court of Appeals had earlier affirmed the theft before he raised the multiplicity claim, this court would essentially be supporting, recognizing, and giving credence to Mr. Dale's piecemeal approach to these appeals. It would be rewarding him for having withheld the multiplicity claim in the first appeal. If he's going to be rewarded for the piecemeal approach that he has taken to these appeals, it's going to raise a host of questions and issues for defense counsel down the road. It's going to raise lots of issues in which a defendant may raise certain issues in a first appeal, and perhaps he raises some multiplicity issues in his first appeal. What becomes then of the scenario in which he prevails in his first appeal on a multiplicity claim and has a lesser conviction vacated? And then the defendant says, you know, you really should have withheld that. You should have pursued my other issues and withheld the multiplicity claim, because had you done so, we could have filed a second appeal, or I could have pursued it upon remand. And had we prevailed then, I could have wriggled out of the greater offense. Here, because you put all my claims in my first appeal, you only got my lesser convictions reversed, and now I have a lengthy sentence over my head. Had you withheld those and held those back, I could have gotten out of the greater offense. That is not a policy rationale that should be supported by Mr. Dale's claims here. Furthermore, when I stand before you and advocate for that position, it's also in part because the state's goal is not to just rack up convictions and counts against somebody like Mr. Dale. My sole purpose is not to just rack up as many convictions as we can against somebody like Mr. Dale. But in his case, when the question becomes, what is justice? Justice is not vacating the aggravated robberies and leaving in place the theft from the victim who wasn't even present when he produced a gun and pointed it at 2 16-year-old boys on a park bench. Justice is recognizing that he was convicted of, and the state proved beyond a reasonable doubt, aggravated robberies are what occurred here when he produced that gun and pointed it at those 2 individuals. He should not, by virtue of his piecemeal approach, be rewarded with this court vacating his aggravated robberies and affirming or reinstating only the theft, when what occurred at that skate park that day was much more than that. Recognizing I'm out of time, I'm happy to entertain questions, but I'd ask that this court affirm the Court of Appeals remedy on the first issue and their holding that the aggravated robbery charges were not multiplicitous.
Thank you, counsel.
Thank you.
You reserve 3 minutes for rebuttal.
Thank you, Your Honor. I guess just a couple quick points with regard to the last few comments of opposing counsel. As far as piecemeal appeals, maybe I'm the exception, but I would not see that as a problem. I don't think any defense attorney taking an appeal in front of this court is going to reserve issues because he's so confident that he's going to get his case reversed and he can raise him on remand back in the district court. But the bigger issue is there's been no legal doctrine, no legal reason why this issue could not be raised when it was. District court addressed the merits, Court of Appeals addressed the merits, but they ignored the stature of the case when they decided it. The Court of Appeals did. And I don't think it can ignore the case in front of it and say, well, we're going to fashion a remedy as if you would have raised this on your first appeal. And that's what they did. Being convicted of the lesser bars retrial on the greater offenses. And when he was standing in front of the district court after having his conviction of theft affirmed and aggravated robbery convictions reversed, he stood convicted of the lesser. For that reason, we think the Court of Appeals erred in its remedy, and this court should reverse the Court of Appeals' find that the aggravated robbery convictions need to be reversed. Thank you.
Thank you. Thank you to both counsel for their arguments. We will now take this matter under advisement.